What's up, guys? Brian Felfel Law Group PLLC here with your Florida Law Weekly Case Update. I've got 6 cases for you this week. Let's get right to it. It's a fresh 6-pack, so let's do it. First case is out of the 3rd DCA. Interesting case. Paternity and when can you order biological DNA testing? And it's an interesting fact pattern. So basically, there's a biological mom and a legal father. Biological mom and legal father acknowledge the legal father's paternity when the child is born. So they sign a voluntary acknowledgement of paternity saying we agree that legal father is the father. What happens later? Biological dad comes in a few years later and says, wait a minute, I'm the biological father. That's really my child. And he tries to come in and file his own paternity action and say, I'm the legal father, and order these guys to undergo a paternity test, order the child to undergo a paternity test to prove that I am the actual biological father. And the trial court ordered the paternity test. Appellate court said, no, you cannot do that. Why? Because there's already a legal father. And it didn't matter that the parties were never married, because there's a bunch of case law talks about the legitimacy of a child and how a child born to an intact marriage is legitimate, and it's hard to prove otherwise. Well, it didn't really matter. The fact that this father is the legal father was the key. The fact that they were never married didn't make a big difference. So because the child has a legal father, you have to find best interest of the child in order to order a paternity test. It's not just a regular, hey, I'm going to order a paternity test. Another interesting fact, though, is that because this child already had a legal father, is a paternity action by the biological father even proper or allowed? Well, the appellate court really didn't get into it, but interesting question, because who has standing to prove that, right? In other words, you could potentially have an action to disestablish paternity, but that would have to be from the actual legal father or the mom, not the purported biological father. And so, since there's already a paternity established, I don't even know if this biological father, frankly, he could be out of luck and may not have any chance at all. So, we'll see what happens. The only chance he may have is just saying that there was fraud or something in the actual affidavit acknowledging the legal father's status. So, interesting case. That was Medina versus Chilaud out of the 3rd DCA. Next case is Dunn versus Flores, another 3rd DCA case. Has to do with relocation. So, if you're relocating, if a parent is relocating before the divorce petition is filed, that's not really a relocation, So if somebody moves, if you're going to move, I guess move before the petition is filed, because then you don't have to plead and prove a relocation case. Then it's just a best interest of the child. What is the actual time-sharing parenting plan? And so that's what happened here. Somebody moved before the divorce. The other party tried to get a pickup order, return the child to the state, and the appellate court said, well, actually, because there was no divorce proceedings at the time, it's not a relocation matter. So they remanded the matter back to the trial court to hold a new hearing, basically on best interest of the child, not the relocation standard. Excuse me. Next case is Voss versus Voss. This is out of the 2nd DCA. I'm just kind of interested in this because I'm a nerd, but differences between unlawful detainer, ejectment, and eviction. So unlawful detainer is properly brought in county court. So is a matter of eviction, properly brought in county court. And if it's a matter of ejectment, that's when somebody has an equitable interest in the property, and that is properly brought in circuit court. So unlawful detainer is when somebody just is there and they're not supposed to be there, they overstay, but they're not really claiming an interest. Ejectment is when they're actually claiming some sort of interest. So this was, in this case, Voss versus Voss, they were claiming an equitable interest in the property, so that had to be brought in circuit court. Next case is Heule versus Humphrey. This is out of the 1st DCA, stalking injunction. This was an interesting case. It's too bad for the person that was allegedly being stalked, I guess. So this is their neighbor, next door neighbors. They got into some sort of dispute. What would the neighbor do? Neighbor kept posting signs in their windows and hanging up skeletons on their front door. And they would dress and decorate the skeletons to correspond to different ways, different things that were going on in the petitioner's life, in the next door neighbor's life. So if the next door neighbor was going to court that day because they knew that they had a divorce proceedings, they would dress up the skeleton in a suit and say, oh, time for court today, with like a big poster or something like that. different things like that. Basically, the appellate court said that's insufficient to show substantial emotional distress because of the neighbor's actions. I guess it wasn't enough just to hang signs and decorate skeletons corresponding to your neighbor. Not enough to show substantial emotional distress, which is necessary for a stalking injunction for harassment. Next case is Lantz versus Gibson. This is a partition action. This happens a lot in our cases. So a husband and wife, they get divorced. They sign a marital settlement agreement that they made by themselves. And so the marital settlement agreement provides that the house will eventually be sold and the proceeds split pursuant to a certain percentage. I think it was 60%, 40%. And it said the wife will be responsible to pay the mortgage. So what happens? The house is never sold because of the market conditions. The wife ends up renting it out, and the wife is paying for the mortgage the whole time. She's also paying for other expenses for the house, upkeep, probably property taxes, other things like that. And so eventually they end up selling the house, and the wife says, well, wait a minute, I'm entitled to an offset against all the expenses that I paid for this house this entire time. And so the husband said, nope, the MSA said that you're responsible for it, and so you don't get anything. You don't get credit for that. Well, the appellate court said just because the MSA mentioned that she's responsible to pay the mortgage doesn't mean that she's not allowed under the statute, under the partition statute, to get credit for all the other expenses that she paid during this entire time. So she's able to get back at least a percentage of that. But again, at the same time, the husband, former husband, is entitled to the rent proceeds during that time. So it would offset against each other. So we don't know what the net amount would be, but if there is a net amount in the former wife's favor of all the expenses minus the rental income that she received, then she would get a credit for that at the sale of the property. Last case is Loumpos versus Bank One. This is out of the 6th DCA. I'm sorry, this is out of the Supreme Court. This is a very important case, especially for estate planning and other things too. It has to do with tenancy by the entireties, right? Those type of accounts that you have typically in bank accounts. This is specifically in bank accounts. If you have a tenancy by the entireties account and it's on the signature card, it will be a tenancy by the entireties account, even if it was created earlier by one of the spouses and then later the other spouse joins them. So that's basically what happened. Let's say, for example, before the marriage, a former husband has a bank account, and then after he gets married, he ends up adding his wife to the account, and it becomes tenants by the entireties, or so he thinks. Well, there was a split decision in the lower courts, in the appellate courts, the DCAs, where one court was saying that because there wasn't the unity of time, where the account wasn't they didn't acquire their interests at the same time because the husband acquired it long before he added the wife. That meant it could not be tenants by the entirety, so then it would only be a joint tenants with right of survivorship, which is a lot better for creditors because then they can attach to it. Whereas if it's a tenants by the entireties account, you can't attach to it unless you have a judgment against both husband and wife. So what this case basically says is the statute essentially redid common law in this regard and said that you don't really need the unity of time apparently in order for tenants by the entireties. If it's a bank account and it's formed and their signature card says tenants by the entireties, it's going to be presumed to be a tenants by the entireties account regardless of whether the new wife or new husband was added later. Doesn't matter. Unity of time doesn't matter. So if you're a creditor, you're out of luck. So that's actually a very good estate planning, if you're trying to avoid your creditors for whatever reason, put it in tenants by the entireties with your wife, and therefore, you won't be able to, the creditors won't be able to attach. I mean, there might be some sort of fraudulent transfer argument there if it was done specifically to evade creditors, but as a general planning practice, you probably want to put it in tenants by the entirety. So add your spouse to it. All right, guys, that's all for today and this week. Hope everybody has a wonderful week. Take care.